Hi everyone, my name is Tara Bear and I'm here to talk to you about books, libraries, and democracy. Some of you may have heard me speak before on behalf of Protect Huntington Beach. I've done a few speaking engagements with them, but I wanted to have this information available for you online. So, a legal disclaimer. I'm not a lawyer. I am not barred. I haven't gone to law school. I don't have my JD. So anything that I'm saying in this presentation should not be considered legal advice. However, I did spend a lot of time meticulously researching all of the court cases, all of the information that is presented here, and I've put in considerable effort to make this material as accessible as possible, but it is not legal advice and it should not be taken as such. If you feel that you have a legal issue after viewing this presentation or hearing me speak, then you should consult with the appropriate counsel. But this presentation and the papers that I've written and the speeches that I've given and the workshops that I've been to is just a response to the Huntington Beach Ordinance 4318 and Huntington Beach Resolution 2023-41, and they are the reflection of the thoughts of an informed and curious mind. Also on that note, I feel that very strongly that libraries are a place of quiet reflection, of contemplation, a place to learn, a place to absorb information, and that we should be supporting our libraries as they allow people from all different walks to absorb and consume information that they want without having any barriers of access placed in front of them. So that is the perspective that I am coming from as I am giving this presentation. Okay, let's get into it. First, we're going to talk about Huntington Beach Ordinance 4318. You can see on the slide I have 4 bullet points here, and these are the 4 things that really stick out when we talk about the ordinance and how they play into the different court cases that are established and when we talk about relocation or book banning. So let's go through them. We have Huntington Beach Ordinance 4318 establishes a politically appointed 21-person parent-guardian review board. So a politically appointed council is one that has been created by politicians and whose members are appointed without input from citizens. So they aren't elected, they're chosen by people who are already seated in power. In the case of Huntington Beach, this means that the city council members are appointing the people on this 21-person parent-guardian review board. The citizens are not. The library is not. You are not electing them. They are an extension of the city council, basically. And even though it's called a review board, it remains politically appointed committee that is interfering with the administration of the public library, and it also deliberately excludes input from professional librarians hired to fulfill their duties in the public library, while also requiring their participation, which seems a little counterintuitive. The existence of the review board jeopardizes the decision-making process of trained professional librarians in creating an unbiased, age-appropriate children's collection at the library, and it does that by either suspending books from circulation or removing them from the children's section altogether and placing them into the adult section. There's a bit of case law established on how this is unconstitutional, and we'll go over that later, but I just want to establish the main points that we're going to be talking about today. The ordinance also defines community standards, sexual content, and sexual reference. In particular, community standards is really important because that ties back to orthodoxy, and orthodoxy ties back to obscenity, which is how many book banning committees are trying to take books out of the children's section and put them into the adult section, or to just ban them outright or to suspend them. So we want to make sure that we know that the ordinance is defining community standards while also defining sexual content and sexual reference, which are not considered obscene by themselves, according to the established case law. This The ordinance also says that the 21-person review board is only required to meet twice per calendar year. That's not very often, and sometimes if library material is suspended indefinitely, it can be considered a violation of your liberty interest or a barrier of access. So that's like an important thing to know, that it's only required to meet twice per calendar year. The board can decide if they want to meet more than that, but they're not required to. And then finally, one of the last things that you can see in Ordinance 4318 is that it very clearly states that all decisions made by the 21-person Parent Guardian Review Board are final and non-appealable, which goes directly into our 14th Amendment. The next thing I want to address is Huntington Beach Resolution 2023-41. So this is the resolution that actually authorized the relocation of children's books from the children's section to the adult section, and it establishes Huntington Beach's official standards for children's book procurement at the public library, and also for the review of children's books that are currently in the library, and it supports the creation of Ordinance 4318. So I don't talk about this one as much, just because it really just ties into Ordinance 4318, and other than being like the official authorization for the relocation, it doesn't like establish anything separate on its own. I also want to touch very briefly on the relevant court cases that I used while I was researching. Here's the list. I definitely recommend that you look these up and you read about them, even if you can't access the full court case, if you don't have those capabilities. There should be something online about all of them. And in particular, the Sund versus City of Wichita Falls, Texas is an important case that I really reviewed as I was going through and comparing the decisions that were made in that court case with the situation that we have in Huntington Beach now. And then Board of Education, Island Trees Union Free School District number 26 et al. Versus Pico. That's a very important Supreme Court case that talks about the different established case law as far as public libraries and then school libraries go. Miller versus California is important because it goes over obscenity standards, and then the rest of them are just important for other different small things, but, well, none of it is small, but it's important for other different things. And I do recommend that you research them a little bit to get a grasp on how these all fit into our situation here at Huntington Beach. Library facts and a discussion on definitions. So, you can see here the first bullet point says public libraries are limited public forums, and that's going to be a fairly new sentence to many people, so I'm going to explain it a little bit. Politically appointed councils that oversee public governmental institutions, such as libraries, can infringe on citizens' First Amendment rights during their oversight. And that happens because there are broader protections for First Amendment rights within different types of forums. And so the library, the public library, is classified as a limited public forum. And knowing the classification of a public library is important because it establishes to what extent your First Amendment rights can be abridged, or any of your constitutional rights can be abridged, and what the abridgment tests are that can be applied to make sure that you're not experiencing a barrier to access or having your liberty interest infringed upon. So basically, it's important to know that the Huntington Beach Public Library is a limited public forum, and that means that much of the case law that we're going to talk about today does apply to it, because the case law and the cases that were tried also happened in other public libraries that were limited public forums, which means that the limited public forum is subjected to the same amount of abridgment standards pretty broadly. So the other thing we want to talk about is orthodoxy and the power of community standards, which is going to tie back to Miller versus California. And the Supreme Court has made it clear that government officials alone cannot define either orthodoxy or community standards on their own. If they try to do this, it's because they are trying to manipulate these standards for their own purposes. And the Supreme Court has set forth the Miller test to make sure that this isn't happening. And the Miller test, as it's defined in Miller versus California, part of that test requires that any material that is being questioned must have modern or contemporary community standards applied to it, and then they must find that the entire work is appealing to prurient or interest. But the Supreme Court made it very clear that government officials are not allowed to define either orthodoxy or community standards on their own. And you can see that in Huntington Beach, Ordinance 4318, and by extension, the Review Board, is saying that they are the only body allowed to define community standards because they define it in the ordinance. And it says in the ordinance that the board's determination regarding whether books are acceptable for children's access, including books that may contain sexual content or sexual references, is up to the board's determination. So community standards is the board's determination, is what Ordinance 4318 says. And so that clearly allows the board free rein to define and discriminate against any material they personally see unsuitable in the children's section, which is the opposite of what the Miller test is supposed to do. The Miller test is supposed to say, okay, we're really making sure that the material we want to remove is obscene, that it's appealing to prurient interest, and that has to be defined by people, not government officials alone or governments alone, but by people in the community. And so in this way, like this ordinance is trying to circumnavigate the Miller test by, one, cutting the public out of the deliberations by making a politically appointed council, and then two, just straight up defining community standards as whatever they want. So that can be unconstitutional. So you can also see that Ordinance 4318 defines sexual content and sexual reference. That's fine, they can do that, but in the grand scheme of things, those things are not considered legal terms, and generally when we're looking at censorship within public libraries, things must be, like if the censorship is occurring, it must be viewpoint neutral, and it must truly be obscene or pornographic, but pornographic has to also relate back to obscenity. It all goes back to that prurient interest. And if it's not hitting obscenity, if it's not meeting all of the requirements for obscenity, it's going to have a difficult time to be viewed as like a viewpoint neutral removal or relocation. So things of a sexual content or like sexual reference on their own are not considered obscene. No one would look at Michelangelo's David and consider that obscene, but if you applied these definitions that they have put into Ordinance 4318, Michelangelo's David would be considered obscene. So we know that sexual content, sexual reference do not always equal obscenity. So a little bit more on community standards. You as a citizen have more right to dictate what your community standards are than your government officials do, whether they're elected or not. But the community standards can't be tailored to the most Puritan or to the most permissive views. They have to be somewhere in the middle. And if they aren't left somewhere in the middle, then they are left open for abuse, which can sometimes be referred to as a heckler's veto. If you're taking something out of the library, it could be considered a heckler's veto. And so, what is a heckler's veto? A heckler's veto is when a small vocal group of citizens do not like something because it does not align with their viewpoint, religious views, perceptions of right or wrong, ethics, morals, any other subjective reason, and they decide that they want that material made unavailable for everyone in the community. So the removal of material through a heckler's veto, such as a 21-person group's idea of what is right or wrong, is unconstitutional because it is limiting the free speech or the First Amendment rights of their fellow citizens. So that takes us right into your First and 14th Amendment rights and how those are applied in book banning or relocation or book censorship within the public library. So a basic overview. The First Amendment not only secures your right to free speech, but it also secures your right to receive information. The Supreme Court made that very clear. So if there is a barrier of access, such as relocation, censorship, removal, unremovable internet filters that are blocking appropriate content in the library, or indefinite suspension of you or material outside of the library's conduct or collection policy, that could be considered a barrier of access, which could indicate that there is an infringement on your First Amendment right. So Ordinance 4318 enacts the relocation, Ordinance 4318 and then also the Resolution 23-41 enacts the relocation of age-appropriate, non-obscene material from its proper location to an improper location. So that would be creating a barrier of access because people would not be going to look for this information, these books or whatever else from their where the space where they should be to a space where they shouldn't be. That's considered a barrier of access. If people don't know that it exists because it's not where it's supposed to be, that's a barrier of access in public libraries. So while the review board also, it has no limitations for how long contested material can be suspended while it's under review. And so that also creates a barrier of access to material, and it also introduces the element of due process. Due process. Due process means you have the right to appeal a decision when your liberty interest is potentially deprived. And a liberty interest is, in this case, would be your right to do constitutionally protected acts, such as receive information without a barrier to access. So you should be able to look at these books without having them being relocated or having them be indefinitely suspended or whatever else they're going to cook up. So due process is the right to appeal that decision, and that's protected under the 14th Amendment. So you'll remember back in our definition slide, it very clearly said that all decisions made by the review board are final and unappealable, which is a violation of the 14th Amendment. If your government makes a decision that directly affects you, you should be able to appeal it. So because your liberty interest to access this information is being barred from you. So they are creating, by not allowing you this due process, by moving these books into a different location, they are creating this barrier of access, which is creating a deprivation of liberty interest. And if you are experiencing a deprivation of liberty interest, you are entitled to due process under the 14th Amendment. So that's really important to know. That's kind of how the First and 14th Amendment are going to tie into, they do tie into Ordinance 4318 and Resolution 2023-41. And these these points are backed up in the case law. If you want to go and review those cases that I suggested earlier, you'll be able to see how this is all delineated in those cases, particularly Sund, and then also in Pico, Miller, LG, and the rest of them. Viewpoint discrimination is really important when we're talking about book banning, relocation, and censorship in public libraries and in school libraries, because the Supreme Court has ruled in Pico that whoever is removing or relocating books without documented, transparent, viewpoint-neutral processes, they are engaging in viewpoint discrimination. And viewpoint discrimination in limited public forums, or your public library, is considered unconstitutional under the First Amendment, and that was ruled in the Supreme Court case Pico. So the removal of books by politically appointed councils that do not meet the Miller test and are otherwise relevant to the library's collection is considered viewpoint discrimination. I'm sure many of you might remember that Councilwoman Natalie Mosier even tried to introduce a measure in, I believe it was October of 2023, to have transparent, clearly written out rules about what is going to put a book up for relocation consideration, or just have any type of guideline available to the public that's transparent, that's easily accessible, and she was struck down. The rest of the city council members did not want that, and so it was struck down. It wasn't the rest of the city council members, it was the city council members who enacted this ordinance, but she was the one who introduced that push to have transparent recording for this review board. Anyways, also, it's really important to know that the purpose of the library is not to dictate how parents or guardians raise their children, but it's rather to facilitate the freedom of expression. It is a public library. It is meant for everyone. It is not meant just for kids. It is not meant just for those of specific viewpoints or religions or walks of life. It is for everyone in the city. And so any library material that is not obscene, and it has scientific, artistic, educational, political, literary, whatever, and is otherwise covered to some extent in the library's physical collection, it cannot be removed simply because a small faction of people disagree with the message or the contents of the book. And it is extremely important to make sure that other citizens are not imposing their personal viewpoints on other citizens by requesting specific material be removed or relocated from the public library just because that material may deviate from their life perspective, their religion, or their viewpoint on any kind, on any manner. It's not the purpose of the library, it's not the purpose of the local government to dictate what information its citizens consume, but rather it is the purpose of the public library to facilitate freedom of expression, to protect citizens, both minors and adults' rights to receive information, and to remove barriers of access to information and not create them. So the relocation of these books, since we can't say that there's really any viewpoint neutral reason for city council to be removing, or for this review board to be relocating these books, or to not acquire these books, or to take these books out of circulation, there's no documented reason for why they're doing it. So we can basically just assume that it's not viewpoint neutral. It is viewpoint discrimination, and it is the review board's own views, and it is not a reflection of their interest in any child's well-being. It is just a reflection of what they want you as citizens of Huntington Beach to consume as far as what is available in the library. This slide is going to be a little lengthy, but it's going to have the most pertinent information as far as case law that parallels with the situation we have in Huntington Beach. So the case Sund versus City of Wichita Falls, Texas, was a case that was litigated by concerned citizens of Wichita Falls, Texas, because children's books in their public library were being relocated from the children's section to the adult section. And the way that was happening, they had a resolution that said if 300 library card holders in the area signed a petition, no further review was necessary by the library, by the city council, by literally anyone else. They would just remove that book from the children's section and then they would put it into a restricted part of the adult section, which is fairly similar to what's happening with Ordinance 4318. So just for a bit of scale, at the time this case was filed in 2000. The city of Wichita Falls, Texas had about 100,000 citizens, and they were trying to give power to 0.3% of the population to make decisions on suitable material for the rest of the population within the public library. So, and to give you a little scale for Huntington Beach, Huntington Beach has a population of about 199,000 in the last census. And so Huntington Beach City Council and this ordinance is trying to give away the right to make decisions, to have everybody make their own decisions on what they consume at the public library, to only 0.02% of the population of Huntington Beach. They're not providing the criteria for relocation or suspension. It does not require the members of the review board to have read the books before regulating them, and it purposely removes any expert professional opinion from the matter by excluding librarians from serving on the review board. So that's important. So in the case of Sund, the judge for this case held the following, that the resolution passed by the city council violated patrons' First Amendment rights to receive information, that the public library was a limited public forum, which is good because that means that this case can apply to Huntington Beach's public library, which is also a limited public forum. That the resolution was an improper delegation of governmental authority to private citizens under Texas law, and that also translates over to California law because it is cited in the California Constitution. And finally, that patrons' First Amendment rights to receive information would be irreparably injured if denied permanent injunction, which is the reversal of the resolution to relocate the books. So basically, he said all of these relocated books from the children's section to the adult section need to go back, because if they don't go back, people's First Amendment rights will be continuously injured. So it's very easy to see that there's lots of parallels between these cases, between this case and what's going on in Huntington Beach. But there's a few other things I want to talk about. So under the First Amendment, states may regulate children's access and their right to receive information to materials that are not deemed obscene for adults, but material can be deemed harmful to minors, and that might put them up for the chance to be regulated, so relocated, suspended, removed, etc. But in order to do that, in order to be considered harmful to minors, they must pass the Miller test, which I mentioned a little bit earlier. And it is the current testing standard for obscenity and has been reinforced by other Supreme Court decisions since it made it to the Supreme Court. And so basically the Miller test says that the average person applying contemporary community standards would find that the work taken as a whole appeals to prurient interest. The work depicts, describes, in a patently offensive way, sexual conduct specifically defined by the applicable state law, and whether or not the work taken as a whole lacks serious literary, artistic, political, or scientific value. And the California Penal Code generally follows those same guidelines, and it goes into even slightly more detail. And so basically what Ordinance 4318 is doing is it's working around the Miller test. It's trying to manipulate the Miller test using community standard definitions to create things that to label things that are obscene that are not actually obscene, and they're not actually harmful to minors. And you can see that's clear because they define sexual content and sexual reference, which they don't meet the Miller test standards for obscenity. So arguing that books such as The Care and Keeping of You, which is, you can see is on a list of books that to be relocated from the library. It's an American Girl publication that focuses on the scientific and anatomical changes experienced during female puberty. And they're arguing that that has no scientific value, basically, by relocating it. And that seems pretty difficult to prove, especially because the book is a New York Times bestseller. They've repeatedly made new editions due to popular demand, and the book has sold more than 5.1 million copies since its first publication about 20 years ago. So if they're choosing to censor this book, to relocate it, this book has a long, like the city council, this review board, has a long road to disproving that the entire field of anatomy is not scientifically serious. And so that also kind of begs another question. Why are we allowing only adults to browse and look for books on female puberty? It seems that there would be a stronger argument to make that only allowing adults to browse illustrated books on puberty could be pandering to a significantly more harmful prurient interest under the Miller test than parents or guardians helping to teach their children about their anatomy as they're growing up. Sund also takes the time to address concerns on obscenity. It's pretty well known that all nudity cannot be deemed obscene, even to minors. We talked about Michelangelo's David, that would not be considered obscene, and that they're trying to remove the community's ability to define their own community standards. And so basically it's just really important to know that when libraries, when review boards, when city council, anything like that is trying to create any type of First Amendment restriction in a limited public forum or the library, the only terms that have weight are obscenity as defined by the Miller test, and harmful to minors is another term which also relates back to the Miller test, and then also child pornography, but not just pornography, so it has to be the whole term, child pornography. So you can't rely on the common definition of pornography because it's too subjective to broaden the amount of content that falls under this review board's regulation. And in actuality, the only content that can be regulated in this way is content that is considered obscene. But under Ordinance 4318, material including depiction of sexual organs, such as a beginner's anatomy textbook or a guide to puberty, can be relocated, even though there's no compelling government interest to deprive students or minors of material that has scientific value, even if 0.02% of the population finds the perceived message to be distasteful. So we generally also get the question, I get this question a lot, relocation, how is that banning? How is relocation banning? That's just moving the books from one space to the other. And relocation really at its heart is just a form of censorship, and it's just another way to indirectly accomplish banning. That's just the bottom line. Adverse reactions of a small number of people within the community that result in a violation of it results in a widespread First Amendment violations for the rest of the community is unconstitutional. You cannot go around telling people what they can and cannot consume in the library because your viewpoint might not be neutral. And librarians are trained. They have to go to graduate school. They have to get a degree. They have to take classes on making sure that they're creating age-appropriate, viewpoint-neutral collections for children, that their parents can also help them decide if they want to consume or not. It's not the job of the library to tell parents how to parent their kids. And, but like the penultimate thing about SUND is that it says specifically in the case that those seeking to restrict access to information should be forced to take affirmative steps to shield themselves from unwanted materials. The onus should not be on the general public to overcome barriers to their access to fully protected information. So it is not the responsibility of the entire town to prevent access to information that only 0.02% of the population finds unpalatable. And since there's no publicly accessible, transparent, recorded policy regarding the criteria to remove, relocate, or otherwise regulate children's books that the review board follows, you can just assume that these books are targeted based on viewpoint and content discrimination, creating a burden of access on patrons and creating an infringement on their First Amendment rights. So parents and guardians should be responsible for their minors, not the city council, not the review board, not the library. And by creating this ordinance and by creating this review board, the city is introducing a risk of arbitrary and discriminatory application of viewpoint bias within the library and jeopardizing the First Amendment rights of the Huntington Beach citizens and public library patrons. This slide will be a little bit shorter. PICO is a Supreme Court case that establishes that government and government officials cannot dictate orthodoxy, which relates to community standards, which relates to obscenities. So that kind of creates that little waterfall there. That's really important to know. The removal or relocation of material must be motivated by a viewpoint neutral process, and that process must be transparent, documented, and is subject to due process. So that's straight from the Supreme Court. PICO also establishes that the First Amendment extends to your right to receive information, not just your right to free speech, but as an extension, your right to receive information. And it also says that barring or requiring other patrons in public libraries not to consume information is a violation of that patron's rights. PICO is heavily cited in many of the cases that I mentioned earlier in this presentation, and it is considered kind of a bedrock when we talk about book banning, First Amendment rights, and such. So that's the presentation. I honestly could go on for hours about this topic. I've done a lot of research. I've really just scratched the surface, giving you a little bit of overview of what we're talking about here in the Huntington Beach public libraries. In case you don't know me, my name is Tara Bear. I'm an MLIS student at the University of Wisconsin-Milwaukee, and I'm focusing my studies on law and ethics, particularly in libraries. I work as a law librarian right now, and I've lived in Huntington Beach for about 2 years. If you have any questions about what I talked about here, you can find me on LinkedIn. You can see the URL right there. I'd be happy to chat with you. You can also find me around town. I go to a lot of the Protect Huntington Beach workshops and such. So if you have any questions, please do come and find me or ask me anything that you might have on your mind. I love to have conversations about this stuff. And hope this has been informational and helpful for you as you go through and understand your rights in the library in Huntington Beach.